Vanakkam friends, I hope you are in the best of your spirits as always and consistently preparing with discipline for your upcoming exam. Like all the other videos in this series, let us take 10 questions and learn little more of the system of governance in India, which you all aspire to become a part of very soon. It will be beneficial if you keep your copy of the Constitution of India close for your reference as we discuss the questions. I also recommend you please pause the video as the question is displayed on the screen. Answer the question yourself and only then proceed to listen. And continuing from the last video, on the right hand side of every screen or slide, you will see some pictures which are logos of some regulatory bodies and authorities in India. Your task is to identify them while you listen to the explanations. Lastly, there is some additional learning at the end of the video, like always. Mostly random but relevant for our studies and life as well. So I strongly suggest to complete this video. Even if you wish to skip some part of my talk here because some questions you don't have any doubts or don't want to listen further, do watch it till the end by skipping, or much better option of increasing the speed. Alright, so let us take the first question of this video, and that is the annual financial statement of the Union government in respect of each financial year shall be presented to the House on such day as directed by. Okay, now we know that Article 112 of the Constitution talks about the annual financial statement. In fact, if you read it now, you will see that clause 1 reads that the President shall, in respect of every financial year, cause to be laid, right? So, in a sense, it means that it is the President's responsibility. Of course, it is on the advice of the Council of Ministers, specifically the Finance Minister, who is also the one who lays the statement before the House, and this is just a convention. In the states, you may have seen many times even the chief ministers of the state have tabled the budget of the state at times. Anyway, so it is to be decided and directed by the President of India. Okay, so not a difficult question, and I hope you recognized this logo here. That's BCCI, and good performance. So the next question is Central Bureau of Investigation, CBI, functions under some ministries, etc. are given there. Well, answer is of course known to you. CBI, it traces its origin, to the Special Police Establishment, not Delhi Special Police. Okay, this is much before that. And this Special Police Establishment was set up in 1941. That was during the Second World War. By the government of India at that time. The function of the SPE then was to investigate cases of bribery and corruption in transactions with the War and Supply Department. Okay, War and Supply Department of India. That was during the war. And the superintendence of this SPE was vested with the War Department, of course, because essentially it was the War and Supply Department of India which they had to monitor. Now, after the war also, the need for some kind of an agency to investigate those kind of bribery and corruption cases was felt. And then came the Delhi Special Police Establishment Act, okay, in 1946. DSPE Act was enacted, and this transferred the superintendence of the Special Police Establishment to the Home Department, right? And its functions were enlarged also to cover all the departments of the government of India, all the union territories, and also could be extended to the states with the consent of the state government. Okay, and then much later in 1963, this DSPE, it acquired its more popular name today, and that is the name called CBI. That was after the Santhanam Committee recommendations. If you remember, 1st of April 1963 it came to existence. So initially it related only to the central government servants, but gradually with public sector undertakings coming up, nationalization of banks in 1969, all their employees also came under the ambit of CBI. So essentially it still functions under this Ministry of Personnel, Public Grievances and Pension, because it is essentially, the idea is to keep a check on the cases of bribery, corruption, etc. of the central government employees. Though you'll also see that now the mandate is much broader, heinous crimes and severe cases like the recent alleged murder of Sushant Singh Rajput, the FIR that has been now given to CBI. So all those things are also there, but essentially the origin lies there, and hence it is the PPGP. Ministry. Moving on to the next question, we have the principle of collective responsibility under a parliamentary system implies. Some options are given. A motion of no confidence, if passed, results in the dismissal of the Council of Ministers. I guess this one nobody should have any doubt. This is correct, because one way to enforce this collective responsibility is to the Lok Sabha in our country, or in general to the legislature, where if the House loses confidence in the Council, then they must be, resigning, or if not resigning, then of course they'll be dismissed by the head of the state. Okay, so then second option says no person shall be appointed or continue as a member of the Council of Ministers unless recommended by the Prime Minister. Now, this is also straightforward, though I can sense some people did have a difficulty here. See, the collective excuse me, the collective responsibility of the Council of Ministers is enforced also through the Prime Minister. Since the Council of Ministers has to swim together and sink together, every decision of the Council has to be defended by every minister once the decision has been taken. Any and every disagreement has to remain within the cabinet proceedings. So any disagreement shall be either managed within, the team, accepted by the Prime Minister, or through resignation of the minister, or the Prime Minister's recommendation to the President for removal of the minister, right? So ultimately, this is the spirit behind being one team. They stick together, they stay together, right? And if somebody is not agreeing, then they must leave also. And it is enforced through the role of the Prime Minister there. So I hope you got some more understanding here. And that logo is the AAI. So the next question we have, which of the following is correct regarding the election of President of India? I'm sure we all recall that it is conducted by the system of proportional representation by the means of a single transferable vote. Single transferable vote. It's a single vote that is transferable. So, of course, the MPs and MLAs have one vote each. I saw a lot of you got this right. See, the vote may not be counted as one vote. The value may be different. Okay, it may be in hundreds. But everyone gets only one vote. Whether you are an MP or an MLA who is the part of the electoral college, you get one vote only. Okay, you cast it once, then the value may be very different. Then it says MP, MLA who is also a candidate for the election shall not have the right to vote in the election. Now, why will this happen? There is no necessity for this to happen. Normal election also, if I am a voter of an area and if I am contesting election as well, my voting right cannot be taken away. I have all the right to vote for myself. I mean, there's nothing wrong in that. Or whoever else I feel like. It's all secret ballot anyway. So the second statement is wrong. Okay. So only the first one is correct. And I hope you recognize this logo here, Bureau of Indian Standards. See, we need to perform better. And most of the confusion I saw was in this regard. Anyway, please ensure these things don't happen. So the next question we have is the Constitution of India mandates which of the following two, before entering their office, to make and subscribe an oath or affirmation before the President of India or some person appointed in that behalf, okay, by the President. So, three options are given, and by now you must have realized that none of them have these kind of conditions. In fact, you may recall recently, few days back, having seen taking over by Mr. P.K. Joshi as the chairman of UPSC. The oath was administered by the outgoing chairman, Mr. Arvind Saxena. See, understand. Let's understand this idea here. So we know the three wings of the state, the government, that is the legislature, the executive, and the judiciary. And the head of the state for all of them is the president. So the president will administer oath to the main functionaries in all of them. So for legislature, let's say all the members, right? Executive, all the ministers, right? Your prime minister, cabinet ministers, other ministers also, right? Similarly, in judiciary, you'll have the judges of the Supreme Court, you'll have the Chief Justice of India. All those oaths will be administered through the president or somebody nominated by the president. We know that the minister has to be administered the oath by the president only. For others, somebody else may also be possible to be deputed. Now, there is only one more agency, the Comptroller and Auditor General of India, which is independent of the three wings. The CAG's oath is also to be administered by the President. Other than that, there is no other oath in the Constitution which the President has to, has to administer outside the legislature, executive, judiciary and the CAG. So for all of these, actually there is no specific provision for any kind of a oath. There is no oath prescribed in the constitution either for them. So they pretty much take the same oath which they perhaps have taken when they joined the civil services once again. Anyway, so the answer for all of this is actually none of them. 40 of you got it right. That's good enough. I mean, I'm happy because this is not that straightforward a question. Okay, so question number 436. The next one here, the provisions of Constitution of India concerning with the Union Judiciary can be amended by. Now see, Supreme Court being the common court for the centre as well as the states in India, it is of course an essential part of the federal principles of our constitution. And hence, any amendment in these provisions of the Union Judiciary, the Supreme Court, it will require an amendment procedure where the states are also involved. We know that idea, which means under Article 368, it will require a Constitutional Amendment Act, as well as it will require ratification by majority of the state legislatures, at least half of them, right? So, so it has to be done that way only. In Article 368. This is in fact even very specifically mentioned in Article 368, right? It's not something which is, to be interpreted. It is mentioned. It talks about that in Part 5. And by the way, that symbol there is of the Small Industries Development Bank of India with the mandate of financing micro, small and medium scale enterprises headquartered in Lucknow. Read more about them. Okay, next question is, which of the following statements is or are not correct regarding the power of Supreme Court to make rules for regulating the practice and procedure of the court. Okay, straightforward sentence that is picked up from Article 145, Clause 1. And it says it is subject to the provisions of law made by Parliament. Yes, this is correct. It is subject to the law made by Parliament. But the question is saying not correct. Hence, this is a wrong option. Similarly, it says it requires approval of the President of India. Absolutely, it does. So, it is a correct statement. So, it is asking which of this is not correct. This is correct. So, this is also wrong option. None of these should be the answer. Okay, well, less than 1/3. Straightforward provisions. If you don't read many of them, you may not be able to answer. So, it's better to read some of these provisions. 145, I think in several of the previous videos, we have talked about them. Essentially 124 and 143 and 145. But yeah, I mean, that's not an exhaustive list, I'm telling you right now. There's just an indication. Okay, so the next question we have is, which of the following statements are correct regarding the Attorney General for India? Okay, AGI has no executive authority. That is correct. The executive power is to be exercised by the Minister of Law and Justice. And what do we mean by executive authority? I mean, there can be many examples, but just to help you understand it here, let us say the recommendation from the Collegium of Supreme Court that is to be forwarded to the President for appointment of a judge, right? Or maybe an advice to the President to return the recommendation for the reconsideration of the Collegium. All this is an executive work, and this is through the authority of the Minister of Law and Justice. So yes, AGI has no executive authority. This is a correct statement. Then AGI holds office for a term coterminous with the government? No, there is no coterminous nature of their work. The term of every law officer is 3 years, which can be extended for a maximum period of 3 more years. Recently, Mr. Venugopal, who is the present Attorney General for India, his term got over on 30th June and he has been given an extension of 1 year. Right? It just happened last month. So if you have been reading, you would know this anyway. AGI is the primary lawyer in Supreme Court of India. That is correct. We know Attorney General of India has the right of audience in all the courts of India also. So first and third are the correct statements. This institution, I'm sure you know very well, very much in news most of the times of the year, something or the other is happening. We need better performance. But anyway, next question is, which of the following statements are correct regarding the Legislative Council of a state? Okay, total number of members of council shall not exceed 1/3. I mean, we know this is correct. This is actually mentioned in the constitution. While it shall not be less than 40 as well. This is also a correct statement. And it says there is a facility to nominate members from persons having special knowledge in matters of academics, science, social service, art and cooperative movement. Now see, academics, there is no academics here. It is actually literature. While we all know, all of us know that these areas are not that hard and fast, as in that it must be only from science or social service or art. These are indicative areas. But when a statement like this is given objectively, then we have to know that it's not academics, it is literature, science, social service, art and cooperative movement. Not to mention that cooperative movement is also unique and different from the Rajya Sabha nominations that are done by the President of India. I hope you recognized that symbol there at the background. That's your Medical Council of India. Okay, so we are at the last question of this video today. Which of the following statements are correct regarding a bill passed by the State Legislature and reserved by the Governor for the consideration of President of India? Okay, there is no limitation on the power of the governor. Yes, absolutely correct. Governor can reserve any bill. In a way, if you think, there are some kind of guidelines. I mean, they are not really a limitation as such on reservation, but they are limitation in a way on the powers of the governor. Listen very carefully. So, for example, we know it is mentioned in the Constitution that if any bill passed by the State Legislature, it affects the powers, or let's say the kind of work of the high courts, then it must be reserved for the consideration of the president. So that is a limitation in a way, indirectly. But as such, there is no limitation on governor. Governor can reserve any and every bill, even a money bill. And that's where the second statement comes, that the president cannot direct the governor to return a money bill. Absolutely correct. The governor cannot return, and hence when the money bill is reserved for the president, even the president cannot direct the governor to return. And if the president directs the governor to return a bill, of course, which is not a money bill, for reconsideration, it shall be considered by the state legislature within 6 months. This is also correct. There is a timeline on the state legislature. I hope you know that when the state legislature passes the bill second time, then second time again it has to go to the President of India. Though there is no timeline now on the president, it is different from the bill that would have come from the Union Legislature, the Parliament. We have discussed all these things in one of the very earlier questions in details as to what are the powers of the President with respect to a bill which has come from the State Legislature. Anyway, so that's the last question, and well, see, that's again, I call it these basic questions, that what are the basic rules of the game, and we are really struggling. Okay, by the way, that logo there is the DGCA. And just as a last ending learning and note for you, like always, I thought this time I'll discuss something different. So I saw some of my friends also, and your friends also, they have these kind of flags which they use, and I just see that most of them don't know what this is and what this means. It's natural curiosity. We should all have a sense of it. So this is actually coming from the Tibetan culture, 6 syllables, which actually reads Om Mani Padme Hum. Numerous versions are available as to the origin and meaning of this mantra. Literally, it means praise the jewel in the lotus. Okay, praise the jewel in the lotus. Now, it can mean many things. Om Mani Padme Hum. The 14th Dalai Lama, who is the present Dalai Lama, explains it. Let's see if you can understand. He says, by the practice of a path which is an indivisible union of method and wisdom, you can transform your impure body, speech and mind into the pure exalted body, speech and mind of a Buddha. It's the path to become Buddha in your life. So anyway, with that note, I'll leave you to explore more, and I'll see you soon with 10 more questions. Till then, study well. Thank you very much.